Good morning and welcome to today's webinar by Field Fisher and Gardner Law. Before we begin, I would like to point out that this webinar will be recorded. You will, however, not be heard or seen at any time. Questions are, of course, more than welcome. If you'd like to ask a question, just type it into the question pane on your control panel. The presentation as well as the recording will be sent to you after the webinar. And now I'll hand over to our panelists, Mark Gardner from Gardner Law and Kurt Wilhöft from Field Fisher, Germany.
Thank you very much, Aya, and ladies and gentlemen, a warm welcome also from my side to today's seminar on healthcare compliance, and good evening from Munich. Normally it's America first, but Mark kindly allowed me to start today's presentation from an EU perspective. A brief view on today's agenda. I will try to briefly summarize to you the relevance and the importance of healthcare compliance for the healthcare industry. Whenever there is an interaction with a healthcare professional, there are certain rules to comply with, and why this is also important in the European Union. I will start with that as a first step. Then second, I will show you that unfortunately, it's quite a challenge for life science companies to be compliant when you placing your products in more than one market in the European Union, because there is no harmonized standard when it comes to interaction with healthcare professionals. But having said this, I certainly very happy also to provide you with a solution on this, to show you what you can use as legal sources, resources, when you want to obtain a reasonable degree of legal certainty when you have international campaigns that you run in the European Union. This as an introduction, then I will give you also an overview about the general principles that apply for the cooperation with healthcare professionals. Some of you might know them, because there are underlying principles and general rules for most of the industry guidelines in the member states here in the European Union. That is the principle of separation, transparency, equivalence, and documentation. And I will conclude my presentation with an update on the MedTech Europe Code of Ethical Business Practice and the latest developments on this. Starting by hopefully increasing your attention to today's topic by showing you why it is so important to be compliant with the law whenever there is an interaction between your company and a healthcare professional or a patient organization. First of all, you certainly know there are criminal laws in place in Germany only since 2016, in the UK already since 2010, which make any kind of unlawful behavior subject to imprisonment between 5 to 10 years. Then, less relevant than in the US, material financial losses are also a potential consequence in case of corrupt behavior. This is not that much the case here in Germany or other member states, except of course for the UK, or if one of the companies has a direct or indirect link to the US market, then we certainly have the FCPA that also rules. But here in Germany and in most of the member states, when you do a risk assessment, when you are in a gray area, you always take into consideration what are the potential regulatory sanctions. So the worst case situation is for companies certainly a ban to place your product on the market. And then you also take into consideration, would that lead to a bad relationship with your competitor? Most of you might say that it's by nature you have a bad relationship with your competitor, but I'm meaning that in particular for product-related advertisement, most of the member states have the regime of self-regulatory markets. That means that we do not have authorities or public prosecutors monitoring the market, What we have is that you receive a cease and desist letter from your competitor when you're carrying out misleading advertisement, and the ongoing lawsuits in this context are very cost and time intensive, and then certainly reputational damages. You don't want to end up in the headlines of the press. You don't want that public prosecutor is ringing at the door of your company and this action will end up in the newspapers. So these are, in very short summary, the reasons for life science companies in the European Union to take healthcare compliance very serious. And I told you, on the other hand side, it's a serious topic, but it's also a great challenge for international acting companies to be in compliance with healthcare compliance rules, to observe these rules, because different to the regulatory framework, we don't have a harmonized legal standard here. So we are in a very fortunate position when it comes to the regulatory framework for medical devices. We have the EU Medical Device Regulation from May next year on. We have the Directive 2001/83. It's only a directive, but it provides for, according to the ECJ, nearly full harmonization. We are not in this favored position when it comes to interaction with healthcare professionals, when it comes to transparency obligations, disclosure obligations, when you grant benefits or benefits in kinds to healthcare professionals or patient organization, when it comes to product-related advertisement, any kind of interaction with healthcare professionals or healthcare organizations is not subject to harmonization in the European Union. Nevertheless, there is a good means or a good instrument, a good tool to obtain a reasonable degree of legal certainty for international campaigns or activities without exploding legal costs. There are two sources available that you can use, and it is best practice to use them. First of all is the MedTech Europe Code of Ethical Business Practice, issued in December 2015, and there is also updated on a 2-annual basis the MedTech Europe Compliance Handbook. You might be aware that both of these, the Code of Conduct, MedTech Europe Code of Ethical Business Practice, is an industry guideline. Nevertheless, it provides very well guidance with respect to any kind of interaction concerning company events, educational grants, charitable donations, arrangement with consultants, advisory board meetings, speaker arrangements, research, non-interventional studies. So whenever you are planning to carry out an international activity in this respect, the MedTech Europe Code of Ethical Business Practice is a good legal source to obtain guidance on compliant behavior. I said it's only an industry guideline. That on the one hand side means it's not directly applicable to those companies not being a direct member to MedTech Europe. Nevertheless, it's our consistent experience here in Germany, and we also hear this from other member states, that national courts take this industry guideline into consideration when interpreting their national law. So it's becoming a de facto law, as we call it. So I can again emphasize and stress that the MedTech Code of Ethical Business Practice is a reliable source also to have a good overview on the national legislation and case law in the member states in the European Union. The second source that you can use, very unknown, is the MedTech Europe Compliance Handbook. This is not the Code of Conduct, but it's a compliant handbook which provides an overview on the national particularities, on the national rules on interaction with healthcare professionals. It's a pamphlet of 150 pages with 29 country chapters. And I give you an example why it is so helpful. So on each chapter, on each country chapter, you have a table which summarizes if there are additional or more restrictive requirements in the respective country. So first of all, you have the source, the code of conduct, and then second, in the handbook, you can see here from the snapshot on this slide, first UK, it's not limited to the European Union. It's updated October 2020, so it's very recently and a very up-to-date source. And then second, when it goes to the UK, you can say for educational grants, for company organized events, consultancy arrangements, and also for fair market value, there are no stricter or country-specific requirements in the UK in comparison to what MedTech Europe Code of Conduct has been established and ruled out in their industry guidelines. So, having to give you a brief summary, compliant behavior is very important also in the European Union. We have no harmonized standard, so potentially we have 27 different different compliance regimes here in the European Union. Nevertheless, we have good legal sources that provides guidance to you. And when it comes to country-specific requirements, you also can have a look at the compliance handbook of MedTech Europe.
If I can just interrupt you for 1 second, we already have our first question, and that would be, are both documents available to non-members as well?
Yes, they are. I'm not sure if the compliance handbook is available on MedTech Europe's website, but certainly the code of conduct is. If not, if the compliance handbook has only been sent to members, then I'm very happy to provide it. Just reach out to me, send me an email. I'm very happy to provide you with this PDF document.
Thank you.
So now I'm giving you a summary of the general principles for cooperation with healthcare professionals and healthcare organizations, which are the underlying principles for nearly every legislation concerning healthcare compliance, but at least for sure for all of the national industry guidelines in the European Union. This is the principle of equivalence, transparency, separation, and documentation. The principle of equivalence, you certainly are very well aware of the principle of fair market value. This means that the remuneration paid by the healthcare company for a service rendered must represent fair market value. So you're not allowed to overpay a healthcare professional, and you always have to take into consideration the qualification, the expertise, and also the experience of the healthcare professional and the actual service that is required to be rendered. To give you an example, for Germany, we do not have any case law from our national courts what fair market value is. We nevertheless have arbitration boards that make decisions on infringements on industry guidelines. And we have a decision on fair market value saying that whenever there is an average or a service that requires an average qualification, 160 euros hourly fee is fair market value. This decision is quite old, and it only requires an average qualification, so you can take into consideration when you are engaging a key opinion leader for speaker service on an international conference. You can go up to 200, maybe to 250, but all above this is quite risky. And this is the benchmark and the standard for Germany, a high price country So you might consider this somehow as a general rule for all member states in the European Union. Our advice is always don't go above 250 euros. Rather do make up to your cooperation agreements, pay remuneration for preparation of the service, follow-up meetings, or maybe utilization rights of the slides, if it's, for instance, a speaker service. Also always important is the benchmark for business meals. This is in Germany 60 euros. This is roughly it. I heard in Italy it's 70, 80 euros. In Spain it's also 60 euros. But if you have this in mind, this benchmark 60 euros, this is roughly the cost limit that a healthcare professional can expect when there is a business lunch or dinner with one representative from a life science company. Gifts, in general, still allowed if they are of minor value, but the best practice and common practice is to not do any gifts. This is socially not accepted anymore, and also the value of providing branded pencils is more and more questions. So I can say, at least in the pharmaceutical sector, pharmaceutical companies are not providing gifts anymore in Europe, and this is getting more and more the tendency also for the MedTech sector. One comment, because this is always of interest, certainly what is reasonable and necessary accommodation, and also with respect to traveling. It's then certainly, when it's accommodation, luxury hotels shall be avoided, and venues known for their entertainment facilities are not allowed. And when it comes to flights, intercontinental flights, business class is allowed. In Germany, we are a bit less strict. Business class is allowed if a flight is longer than 4 hours. In Austria, it's 5 hours. So, but this is roughly it that you can have in mind. And these are my examples for the principle of equivalence. The next one is the principle of transparency. The hottest and most discussed topic is always when you engage with a healthcare professional that is employed at a medical institution, you have to obtain the employer consent. The best practice changed here a bit in the recent years. Formerly, like 5 years ago, it was common practice to include a clause in the cooperation agreements that the employer consent has been indeed obtained. Now, then the next step was to make this employer consent as an addendum or an annex to the engagements, to the contracts, and now it is common practice also in the medical device sector to obtain this employer consent by a signature on the agreement, on the two-party agreement between the life science company and the healthcare professional, whereby the employer confirms that he has detailed knowledge of the requested service of his employee and that he consents to the service to be provided. Then also difficult to deal with disclosure of benefits in kind granted to healthcare professionals. There is also no harmonization in this respect. We have a few countries where it is required by law. For instance, in France, Law Bertrand, you all might all be aware of the French Sunshine Act. This is different in Germany. We do not have such a law. And our industry guidelines, our industry association said, if it's not required by law, why should we then include it in our industry guidelines? And so there is a complete gap on disclosure rules here in Germany, except for educational grants, but this is the only exception. So this is quite interesting. I have to say this is for Germany for the medical device sector. It's different for the pharmaceutical sector, of course. And then certainly always disclose any potential relationships or relationships with the medical device or the pharmaceutical industry when presenting as a speaker. This is my last example for the principle of transparency. Principle of separation, there should be no link between a sales transaction and a corporation. So the corporation and the remuneration paid shall not unduly influence the therapeutical decision or the purchase decision of the healthcare professional or the healthcare organization. This is an example for the principle of separation. And finally, principle of documentation. Everything should be documented in written form. And the overall principle behind this is produce evidence and record and retain this evidence for a reasonable period of time, meaning if you have a cooperation agreement with a healthcare professional, keep it for 3 to 5 years. Also request work evidence, so ask for status and activity reports. And very brief update on the MedTech Code of Conduct. The good message is when you see the last update was from 1st January 2018, it's a reliable source. It's not subject to constant updates or regular updates. The last one was January 2018, so already 3 years ago. But there was included a strict recommendation for MedTech companies to not financially support the passive participation of healthcare professionals at third-party organized educational events. You might know this topic from phase out of direct sponsorship. It's already the case for you in the US for a longer period, but it took a bit that everybody was aware that it's actually socially not accepted to grant partly substantive financial support to healthcare organizations or healthcare professionals for purely passive participation on third-party organized educational events. It is still possible, but on a different route, on a different way. You can grant an educational, you can submit an educational grant to a healthcare organization, which then selects on its own discretion which employee is allowed to participate to a third-party organized educational event. But it must be very clear and sure, also in this written grant agreement, that the granting life science company has no power to select, no responsibility, no competence to select which healthcare professional finally is allowed to go to this medical conference. The only exception on the non-harmonization for disclosure rules is for these educational grants. Educational grants must be published, either on basis of the national law that is applicable. If there is no national law, then the grants must be published on the website of MedTech Europe. So thank you very much. This is my insights and updates from Germany here for the European Union. And Freya, I'm not sure if there are any questions in the chat room.
There are indeed.
Oh, great. Please.
Yes. There are actually a couple of questions. Let me just read them. So the first participant would like to know if you could mention again which body has established the FMV and meal levels in Germany.
That was the arbitration board of the Association for Research-Based Companies, VFA, Verband Forschender Arzneimittelhersteller. That was an arbitration board decision from 2008, in which they had to assess the fair market value for a service a healthcare professional provided in the context of a non-interventional trial in einer Anwendungsbeobachtung. And again, I'm very happy to provide the precise source for that, but it was the FSA Schiedsstelle.
Thank you. The next question is, what are utilization rights?
With utilization rights, I have mentioned this in the context of don't go above 200 or 250 euros per hour, because then you get in danger that a public attorney or responsible authority will assess this as not anymore as fair market value. What you could do, you include further elements, further service or further work that has to be done by the healthcare professional in the respective agreement. For instance, if you want to charge for speaker service 1,500, or you want to pay for it because otherwise you don't get the key opinion leader to engage with you, you have to pay 1,500 euros. You would include 4 hours preparation time, 1 hour speaker service, follow-up meeting, and then also the utilization right to use the slides that he has produced. So you request the right to publish or to submit to other third parties the slides that have been produced in the context of the speaker service. That's what I meant with utilization rights.
Great, thank you. We actually have a couple more questions. So I wanted to ask you if we should proceed with Mark's part first and then do a Q&A session later, or should I ask more questions now?
I would keep going, Freya. I think let's get those questions in.
Okay, perfect. So the next participant would like to know, is employer consent required to invite a German HCP to a meal if there are no fees or travel expenses undertaken?
An employer consent you only need if the healthcare professional provides service. If this is only a business meal where you discuss future projects, then you can do it. There is nothing against it, but it's not required. It's not best practice to do so. Only if there is service rendered, an employer consent is very strictly recommended.
Great. And the next question is there a recommendation how to deal with countries where employers' consent are not given, e.g. the US for liability reasons?
If I understand the question correctly, we always advise companies, if they are not able to get the employer consent, although the national legislation is requiring it, to not engage with this healthcare professional. Employer consent is a very hot and strongly discussed topic, so I would not advise companies to, be flexible in this respect. So I hopefully answer the question by saying don't engage with this healthcare professional if you are not able, for whatever reasons, to get the employer consent from his employer.
Thank you. And also, if you have any further questions, you can also always write an email to Kurt Wilhöft or contact us. So we actually have 2 more questions coming in. One being, is it correct that enforcement in Germany must arise from a third party, competitor complaint, and probably also from internal whistleblower complaints, so the regulatory authority cannot initiate cases itself? If so, okay, sorry, there's more? If so, is this also true of the other EU member countries?
I can speak surely for Germany. Certainly, competent authorities can initiate enforcement actions, but they don't. They have the legal power to do so against pharmaceutical companies and certainly also for manufacturers of medical devices. But they are not monitoring the market. Even sending a notification to annoy your competitor to his or her competent authority does not make them become active. I can't really explain why, but what I can say is that we have a self-regulatory market, and if you are in the context of product-related advertisements doing misleading advertisement, then it's always the competitor who's sending you a cease and desist letter. This you take into consideration for your risk assessment. On the one hand side, you can say, if I have a good relationship or a gentleman agreement with my competitor, I can have very strong promotional claims in the market that I cannot fully prove by scientific data, but nobody will complain. So I can go ahead with it. But on the other hand side, you can also get into a very stressing relationship with your competitor where the only aim of your legal department is to sue or to engage your competitor in lawsuits. So this is something that is taken into consideration for the risk assessment for interactions with healthcare professionals.
Thank you. And the exact same participant would also like to know, how can a small company effectively monitor things like competitor HCP compensation?
You can't. There is, at least for the, again, for Germany, there is an industry guideline for the pharmaceutical area where you have to disclose benefits, financial payments that you made for healthcare professionals. But the disclosure requirements only say you have to disclose the entire amount that has been granted. It's not that you are obliged to also disclose the hourly fees that you are paying to this healthcare professional. So this is not a mean, and this is everywhere the same in all member states. But you have to have investigational talent, so to say. For instance, when your sales force has a good relationship to a healthcare professional, then they speak about it. They get a copy of the agreement. But this is rather rare that you have such evidence and that you can, on a properly basis, on a solid basis, assess a fair market value that your competitor provides to the healthcare professionals. And this is maybe also the reason why you rarely have case law on this. And as already been asked and mentioned, it's only this one case of the FSR arbitration board where you have concrete numbers with a legal reasoning what is fair market value.
Thank you for your answer, and also thanks to all the participants who posed these questions. Let's now switch over to the other side of the pond with Mark Gardner.
All right. Thank you, Freya. Okay, just adjusting my screen here slightly. So thank you very much, Cord. That was excellent. That was a wonderful overview and very helpful to the participants here. I'm going to start off by stepping back for a moment before we jump into some things that are exciting, some developments in just this week that have occurred. For example, if anyone's interested in our program from last year where we were able to do that in person, it is available. The link is at the bottom of this slide. These slides are available to you. We are happy to send them out. Just feel free to send us a note if you'd like them. I think we have your contact information too, so perhaps we'll just send them out but there are resources available on our website for the program for last year. And also, some of you maybe joined just today's webinar, but we had some webinars we had one in October and one earlier this month on privacy first, and then also a regulatory update. So got some great resources out there for you. Oliver Sume from Field Fisher and Heather Potter from Gardner Law presented on privacy, and Cord, we just heard from, presented on MDR on the regulatory update, and Amanda Johnson, Bryn Stanley on the EUA, for example. So we're happy to make these materials available as well. And then lastly, before we jump into today's program, I'm going to be speaking with Dr. Andreas Dreiber, who is also with Field Fisher, on December 3rd. So just a few weeks from now we're really going to focus on M&A activity and how compliance plays a role in that. So please sign up for that if you'd like to hear more. Here's a little bit on my background. I'm a managing attorney at Gardner Law. I'm also an adjunct professor at Mitchell Hamlin School of Law in St. Paul. I've worked in the industry for over 20 years. I've worked at EB3, Acceleration, and MedTech in the past. Those companies have all been bought and are owned by different larger companies now. But my experience at those companies was in commercial roles, for example, as product manager at Acceleration and EB3. So today we are going to discuss virtual detailing. We're also going to go through some fraud and abuse cases. There are a lot of them, so I'll give you kind of a cursory briefing on those. If you'd like any of those materials, case pleadings, whatnot, complaints, I'm happy to send those to you. Amanda pulled those off of Pacer, and we're happy to share those documents with you if you need them. Sometimes they read sort of like a soap opera. And then we'll go through the 2021 Sunshine Act updates. I'm sure probably most of you are aware of what's changed, but we'll give you a debriefer on that now that it's almost here. I'm sure you're all looking forward to 2021 as well. Maybe not more sunshine reporting, but at least the year. And then the bonus surprise, I'll just give it away now to try and keep you tied in here and tuned in. We'll talk about the special fraud alert that was issued on Monday relating to speaker programs. And that is a very noteworthy alert. You know, OIG has only issued 5 special fraud alerts in the last 2 decades. So it's quite interesting that they put that out earlier this week. First, we're going to talk about virtual detailing. If you're from the pharma world, you know that detailing is selling a drug or a product. Med device, you don't hear that term quite used as much, and Cord refers to MedTech, med device, same thing. I'll refer to med device, that includes medical technologies. But yeah, so virtual detailing is really selling remotely, and it's changed, as we all know, during the pandemic. You used to have reps going into hospitals and clinics, and that's happening less now than it was before. So let's just jump right into that. If you are doing virtual detailing, or if your reps are and you're responsible for them, I know we have a lot of attorneys on the line today. What do you need to know? I suspect most of you have probably been dealing with this since March or April, but essentially the same rules apply. So the Food, Drug, and Cosmetic Act, and again, I'm focusing on US law today. The Federal Trade Commission Act, those 2 bodies of law govern what you can say about the products. Of course, any claims need to be truthful, not misleading, consistent with product labeling. That's been approved by the FDA. False Claims Act, Anti-Kickback Statute, fraud and abuse laws, they still apply. So we'll talk a little bit about that special fraud alert. Actually, we'll talk quite a bit about it later. HIPAA, privacy, this is not an entree to start having case files from patients emailed to a rep's email address. They're still going to need to maintain adequate controls, and the company will have to maintain adequate controls around patient information and how it's exposed to that information. Incidental exposure is, of course, acceptable under the TPO exception, but there are limitations. Physician Payment Sunshine Act, to the extent that meals are being provided remotely, that needs to still be tracked. And then finally, the Foreign Corrupt Practices Act, to the extent that, let's say you have staff that are detailing HCPs, but HCP means healthcare professionals, so you'll hear me say that a lot today. You know, these rules, you're gonna need to look at the local rules, of course. CORD, for example, can help with that in Europe, but you'll need to consider, you know, your extension of your practices into other countries outside the US, and the Foreign Corrupt Practices Act is one of those laws that is anti-bribery law that you need to consider. And again, please ask Freya in the chat box if you have any questions, and Freya, just feel free to interrupt me as we go along here. That's no problem at all. A bit of a recitation of what I just talked about, but best practices for remote detailing, you know, making sure all your claims are truthful, not misleading, things are copy reviewed. More specifically, we do see, you know, clients, we've worked with clients on providing meals remotely. Many are limiting the meals that are remote to $20 per person for in-office catering. If you are providing meals in that way, you know, make sure that the food provided is reported. You know, if someone partakes in a meal that ultimately needs to be reported out, so capture that information with a sign-in sheet. You need to think about some of the logistics of that ahead of time. We recommend getting an estimate number of the attendees before you cater such an event. Again, if you are catering such an event, it needs to be part of a bona fide conversation. We'll talk a bit more about that in a moment. So this is not just a dine and dash type opportunity, or you know, where you leave meals and then don't talk about anything relevant to the company or the product. But you should get an estimate of how many people are going to partake in the meal, so that you're not leaving trays of lasagna or whatever it may be left over for staff to consume later. That would be inappropriate. And then you should, you know, staff should go back and make sure that they're being efficient with what they're ordering and effective. So you could do that by finding out after, is there food left over? Did you have 20 people sign up and 10 showed up? So then where did the rest of that food go? And then lastly, consider how much money you're going to pay speakers to ensure that the payment is consistent with fair market value. So this would be, if you were having a speaker program, some of the rules I was just describing are really germane to detailing. But what if you had a speaker program? You know, they don't have to travel when they're providing information remotely. So are you cutting that travel portion out so that they're not getting paid extra? Here is guidance from pharma, and I know we have a mixture of folks from MedTech industry and pharma. Again, I'm gonna put biotech in with the pharmaceutical industry for purposes of this discussion today. But pharma, they are a body within the U.S. Many of you know this, and they're a trade group that provides guidance on how to interact with healthcare professionals. The equivalent on the MedTech side is AdvaMed. MDMA also has a code of conduct, which is very similar to AdvaMed's. So pharma actually came out and said, we're going to provide some guidance to sales representatives. So even for some of you MedTech companies out there, it's, you know, this is persuasive authority for you to think about how you're just setting your policy for remote detailing. Just want to point out that this section that we're about to discuss, or these rules, because they're right from the pharma update. Here's the source at the bottom, so you can read it yourself. But this is related to reps, detailing, and meals. So it's not, this section is not applicable to speaker programs, which we'll get into in detail later. So this is for reps. The rep should be virtually present over the video, audio, conference. So during the event, you know, basically they need to be present. This isn't, hey, here's your, you know, DoorDash is dropping meals off at the clinic, and then they're saying, you know, we'll mail you a brochure and you can read it while you have the lunch. That's not how pharma would not accept that. And just to back up, pharma is not law, but it is codified into Californian law, for example, DC law, and you know, the spirit of pharma is reflected in many other states that have laws on point. For example, Vermont, we all know Vermont, no meals at all. So it actually goes further than pharma. Number 2, I already talked about this, no dine and dash takeout meals, meaning you're just basically giving food away and then not sticking around. You know, the healthcare professional needs to stick around. They can't just take the meal and go. Number 3, any meal offered should otherwise comply with provisions of Section 2 of the Pharma Code. So this is really embodied by AdvaMed as well. The meal should be modest as judged by local standards, provided in a manner that is conducive to informational communication, limited to an in-office or in-hospital setting. Again, that is a unique aspect for pharma, and this is for sales reps and their managers. AdvaMed code does not have that equivalent. And the healthcare professional spouse or other guest should not be included. You know, if you had, let's say you're selling a stent and one spouse is a cardiologist and the other is a vascular surgeon, then they would both be, you know, candidates for a discussion around a stent. So in that regard, there are some exceptions to that rule, but generally, what the rule's getting at here is this isn't an opportunity to ingratiate the spouse with a meal. Number 4, they're just thinking about contactless delivery and food handling and some of the aspects for the customers that where the meals are being brought to that they may have concerns about. I want to direct your attention to, go ahead, Fry.
Yeah, sorry, I just missed this. We actually had some questions already, so I just wanted to read that if that's okay.
Sure, please.
Great. Okay, so one participant would like to know, I thought in my reading of AdvaMed code that was now just about as robust as PHRMAs, isn't it?
I would agree. Yes, it is almost identical in terms of robustness. Their one exception is, and I think I call this out, at any rate, it's the one exception is that a device rep, for example, can take a physician out to dinner. No one's going to dinner anymore, of course, but in the past, a device rep, for example, could, you know, hey, they did some cases and now the rep is going to go to lunch with the physician and talk about a new product that's coming out. And that would be off campus, not within the healthcare professionals clinic. That's acceptable according to AdvaMed. That is not acceptable according to pharma. But that question, the short answer is yes, they are nearly identical, and one exception is the one I just described.
Thank you. And the other question would be, if healthcare professionals are practicing exclusively out of their homes, telemedicine, would a meal to their home be permissible? And if it's considered office, although it is their home?
That's a great question. And I'm gonna ask that person to just hang on because we're gonna talk about that in detail next, because that's a great question. Any others?
So I'll let you go on.
Okay, wonderful. So pharma, and it'd be interesting because that question that was just asked, it arguably could turn on whether the company is a drug company following pharma or a device company following AdvaMed, for example. So with pharma, it's very clear. Meals should continue to be limited to in-office or in-hospital settings. So that rep, you know, arguably, I think that pharma would say that that the home person at home shouldn't get a meal. But I think the question is interesting because that person practices telemedicine, so that is their office. So gray area. You know, I would like to think a bit more about that, but let me jump into this. So the Pharma Code under Section 2, occasional meals are appropriate as a business courtesy in connection with informational presentations only when limited to in-office or in-hospital settings. And then they noted that during emergency periods, meals provided to HCPs by company representatives should continue to be limited to these settings. So that is, I'm going to come back. I'm going to give some more thought to that question from the individual about the in-home piece, but I'm going to kind of stick to the general rules here for the rest of the industry. So what about AdvaMed? It's more or less the same when it comes to provision of meals, silent on the matter of remote detailing and meals. The AdvaMed has not gotten into that. And then this is the exception that I noted. Field representatives and their managers the meals should be limited to in-office or in-hospital settings. So I'm going to give a couple case study examples based on real situations, but I've altered the facts a bit. These are similar questions we've gotten recently. So company wants to DoorDash $20 meals to HCPs at home while they participate remotely in a speaker program. So now we're talking about Section 7 of the Pharma Code, for example, and not Section 2. A company representative will attend remotely too. Is this okay? Answer, somewhat gray. The pharma guidance we discussed earlier is limited to Section 2. And as I stated, Section 7 is speaker programs. So we don't have clear guidance from pharma here. Other considerations, pharma's not law. You'd want to think about, well, what if this is happening in California where pharma's been codified into law? Or what about DC where the same has happened, or Vermont where meals are banned? Or what if it's in New Jersey where there's a limit of $15 for a meal? Or if they're in Minnesota and they've already reached the threshold limit. And by the way, the Minnesota and Jersey laws are, and DC for that matter, are drug only. So those are some of the things you'd want to think about. Also, there's restrictions on meals to state and federal employees. Many states outright bar provision of meals to their employees. And so, for example, in New York, I remember long ago when I was a rep for a laboratory, which is now owned by LabCorp. I worked at MedTech, and I was visiting a lab director in Elmira, New York, and I went to buy her a coffee, which was probably 50 cents at the hospital cafe, and she said, I can't take a meal. I didn't know that at the time. So she couldn't even take a plain old cup of black coffee. But so check those restrictions. And the federal government, of course, has the 2050 rule, which limits gifts to federal employees to $20 per transaction or $50 in aggregate per year. But I think that a company could design a program to do this appropriately because of this distinction between Section 2 and Section 7. Case study 2, company wants to Grubhub, I'm being equitable here to the different services, $175 meals. So we're getting pretty expensive from a local fancy restaurant, includes champagne to HCPs at their office while they participate remotely in a speaker program. Company representative will not attend remotely. Is this okay? And I hope all of you at home are saying, no, that's not okay, because why? The meals are not modest. We're really expensive there. The company representative will not be present. And then consider the federal, state, and local laws. This may violate those as well. How could you turn the facts to make this okay? Make the meal modest and have staff attend. And again, at this point, I think we've got, this is a speaker program. So it's not remote, it's not remote detailing, for example. But this also would be at the office, as I noticed here. So even with pharma, that would be acceptable. If it's at home, that's the gray area. But I think there again, we can, you could debate whether or not you want to do that internally with your team. And back to that questioner's question, we'll add a case study 3 here. I think you'd need to you need to consider internally your risk appetite. What sort of company are you working at? Are you working at Novartis, where you just settled with the government, a 9-figure settlement, and there's actually prohibitions in there. But do you have a big target on you? Are you under CIA already? Have you had past history? Or are you a smaller company that has a robust compliance program and you're willing to take some risk and you establish safeguards to help prevent abuses of meals to someone practicing telemedicine at home? I think the government, honestly, if the OIG were on this webinar right now, they'd say no, because they'd say, the meal is really intended to be a convenience for someone that's staying late to hear a product presentation about a drug or a device. It's not really intended to remunerate them and replace meals that they have. They'd say that doctor's at home, they've already got a cupboard full of food, so they can just eat that food and listen to the presentation. So, but give it some thought. But those are just my, immediate thoughts about that. I'm going to roll through these cases pretty quickly because I'm just looking at time here. We do have another half hour on this webinar, but I will not get into law school type briefing of these cases, but these are the cases we're going to talk about. I could have added more to this list, and just for you folks at home, it's pretty impressive. I've been in the industry for over 20 years, and there's a lot coming through right now in terms of settlements. And these are all this year: Medtronic, Merit, Gilead, Novartis, Pacira, Mallinckrodt. Mallinckrodt's we'll talk a bit about what's going on with them, and DUSA, some Southern Pharma subsidiary. But the cases are coming through. COVID certainly not slowing down prosecutors. Of course, many of these cases were in effect before the pandemic, but so maybe we'll see a bit of a slowdown, but I'm not really anticipating that. So I'm going to go kind of quickly. If you have questions, ask Freya, but we'll start with Medtronic. So I'm sure we all saw that earlier this month, Medtronic, wonderful large medical device company, of course, but they are, they're one of these large corporations that has a lot of reach. So they had they settled with the government for $9.2 million, and the claims under this False Claims Act, I have acronyms in here. FCA is False Claims Act, and Sunshine Act was that the company was paying kickbacks to a neurosurgeon. And in this case, they settled that claim for 8.1 and the other for 1.1. And if we went further with that fine, it'd be 1.15, which is the statutory limit maximum for the Sunshine Act, because the government said, hey, you didn't report all these meals that you bought at this physician's restaurant, Carnival Brazilian Grill in South Dakota, and you knew that he owned the restaurant and you had over 100 meetings there, and you should have reported that. And by the way, the government also took the position, our allegation is that you're bribing this doctor by patronizing his restaurant. So, Medtronic ended up settling for the amounts that I just described. Okay, so what's the takeaway? I'm going to try and give you guys a takeaway on each of these, so it's not just, oh, another company's getting in trouble, so what? How do you put that in? How does that help you to know about this? Well, think about what your team is out there doing, and think about the downstream effects. If there's a physician that owns a business and you see the company using that business a lot, you should be thinking that's an indirect payment to the physician that we're gonna have to report for Sunshine. And then also, should we even be doing that in the first place? There's a lot of wonderful sales and marketing folks out there. I used to work in that capacity. But you gotta pay attention to what they're doing, because they're very clever, and they'll find ways some will find ways to remunerate physicians indirectly, and this is an example of that. So keep an eye on your team. Mallinckrodt, earlier this month, is reported that Mallinckrodt's $275 million in settlements caused it to file bankruptcy. It doesn't help that it has some opioid issues as well, but this is a pretty big drug company that had some settlements for whistleblower suits for inappropriate copay practices, which is a really hot topic in the drug world right now. And they also were, it was alleged that they committed Medicaid rebate fraud. Details I will not get into just because we don't have time. But the takeaway here is that this company is actually had to file for bankruptcy because of compliance risk. So what's the so what on this? You know, it's important. Compliance isn't. This is sort of obvious now. It's 2020 going into 2021. You know, compliance can't be an afterthought anymore. It has to be front and center, or your company might go bankrupt if you're not paying attention. Merit Medical reached an $18 million settlement, another whistleblower suit, and I'll just pause on that. A lot of these are whistleblower suits. You know, everybody's working inside the doors of these companies. In this case, it's a chief compliance officer who allegedly told the company, hey, I don't like what's happening here. Well, apparently the company didn't satisfy that chief compliance officer because he then brought a whistleblower suit against his former employer. Okay, so should be thinking about everything that goes on within your company, you know, that you may be called to task for it by someone that has intimate knowledge of it. I have a lot of quotes here. I won't read this entire slide, but essentially the government said, these are all government quotes. Again, these are all allegations, right? They settled, so there's no admission here. But this company Merit allegedly provided free advertising to physicians. And this is a pretty timely case. We get a lot of questions on in this case, free advertising assistance, practice development, practice support, educational grants. You know, any of these activities needs to either be very legitimate and or the customers need to share in the cost of them. AdvaMed, you know, it was newsworthy last year about this time when their revisions came out to their code and went into effect on the first of the year. They added a whole section on co-marketing or collaborative marketing. So take a look at that. But the government basically said, here, you're helping build your customer's business, and you're not charging for that. And because of that, we ended up paying for things. These kickbacks cause us to pay for things that we wouldn't have but for the kickbacks. All right. It's just very interesting here because this involved a chief medical officer, and he was actually chief compliance officer, but he was a physician as well. And he, you know, warned the company, as I stated here. And again, this you know, nothing was done about it. So just think about warnings that come in, or that if complaints are made, for example, to your hotline, those should be vigorously reviewed. They also entered and followed up on, investigated, et cetera. They also entered a corporate integrity agreement. I'll call that a CIA for the rest of the time we have together. That's a very onerous arrangement with the government. You're not, you know, if you do something wrong, Merit Medical, with all due respect, they're not Medtronic. So, you know, they now have to invest a ton of money and time and effort into their corporate integrity agreement and making sure they're living up to it. So that means they're gonna have to have a monitor come in, an IRO, independent review organization, is gonna have to come in and see what they're doing once a year, you know, for several months. Very, very time consuming and onerous. Gilead, I'm gonna go a little bit faster here just so I can get through all of our materials today. $97 million settlement, September. This was another copay case. So basically the government takes their complaint was, you're covering the copays of patients. And if you didn't do that, we wouldn't be paying for these drugs. So those are unlawful kickbacks. This is another whistleblower case here brought by a sales rep for DUSA Pharmaceuticals. It's a subsidiary of Sun Pharmaceutical Industries. By the way, to cut to the ending to this, Sun Pharmaceutical, the parent, ended up having to enter a corporate integrity agreement, a CIA, you know, for its subsidiary. So this type of exposure goes upstream as well. In this case, this kind of harkens back to the old FDA days when we were, you know, all the cases were about off-label promotion. This case involved the company promoting for uses that were not consistent with the labeling. They were saying you can get the same effect with a shorter incubation period for their product. You also note here in bold, they paid physician, this is allegations, paid physician speakers programs, peer-to-peer discussions promoting the drug with incomplete or misleading responses. So you've got a combination of FDA issues, which then resulted in false claims.
So we have a
Novartis,
question on, oh, sorry.
Yeah, please, go ahead.
So we have a question on the cases. Do you happen to know when the conduct that led to these settlements occurred? Sorry.
Yeah, each one is going to be unique, and I can send that individual the actual court filings if they'd like. Just out of the interest of time, I'm going to keep it moving, but I want to say that this case here with Novartis goes back to 2010 conduct. So the government has an elephant's memory on these things, so it's a bit unnerving if you are a compliance officer, for example, or a general counsel. You may go work for a company tomorrow and be dealing with things that they did or responsible for things the company may be held accountable for things from 10 years ago, right? So that is obviously a hard way to run a business, and but that's where we're at. I thought it was very interesting to hear Cord talk about complaints coming from competitors and the regulatory authorities not super active in Germany. Well, it's 100% the opposite here in the United States. I have several friends that are former prosecutors, and the way they make their careers advance is by prosecuting fraud and abuse. And they're public servants that are doing an important job protecting patients and the treasury. But this is the game. This is to if you're a prosecutor and you bring in a $642 million settlement from Novartis, you're gonna get a lot of attaboys at work. So, but as far as the timelines go, each case is going to be unique. But that just keep in mind that the timelines can go back. I've seen them go back over 10 years.
Thank you.
Okay. Yes. So this is a very interesting case. Novartis case, quite famous. Also a whistleblower suit. I think I have it later in the slide, but going back to the whistleblowers, I think this whistleblower stands to make it's an enormous amount of money. It's a 9-figure reward just for the whistleblower. Former sales representative. There are 2 main claims here. Illegal use of 3 foundations as conduits to pay co-payments of Medicare patients taking these drugs. So same co-payment type issue. I did note that the government gave Novartis credit for a lot of good deeds that it's done to reform its activities around co-pays, for example. But again, the government's they still get fined 51.3 million in this settlement. So even though they've turned things around, the government's punitive in these, as we all know. The second settlement is really timely for what we're going to discuss here shortly and what we already discussed, because it's all about their speaker bureau. So imagine the exposure here. They paid $591.4 million and a $38.4 million forfeiture because their speaker bureau, in the government's view, was inappropriate. That is a huge amount of money that I'm sure the company never dreamed that its speaker bureau could result in such exposure. Just out of the interest of time, I won't read all of these quotes, but the government, these are, their quote, Novartis knew many of these programs were nothing more than social events held at expensive restaurants with little or no discussion about Novartis drugs. Some of the programs never took place. They really hit hard on alcohol. They talk a lot about alcohol in this case. If you look at the complaint, I can send it to you. They also said in some cases, again, you're going to be held accountable for the outliers. So there's examples in here where they're saying, hey, look, they paid $600 a head at this one this one meal of the thousands and thousands of meals that there were. So remember that you're going to be held accountable for the splashy headlines. Those are what grab the attention. And I'm sure what happened in that case is people probably started getting into the the captain's scotch cabinet or the reserve wine at a restaurant, and all of a sudden it's $600 a head, average for that meal. There's also allegations of fishing trips, meals at Hooters, so some of this, of course, as a compliance professional or legal professional, you'd like to think people would use common sense, but you need to, take pains to maybe outline. You can have meals at these restaurants. I hate to bring that up, but in some cases, I think, people are just losing touch with common sense. Again, that was maybe, who knows, maybe that happened once out of 10,000 meals, but it's showing up in the complaint. They had to enter a CIA, it's a fascinating CIA. I'll just read it. CIA requires Novartis to significantly reduce the number of paid speaker programs and the amount spent on such programs. Under the CIA, Novartis speaker programs may only occur under limited circumstances and in a virtual format. We'll talk more about that later. The CIA also obligates company executives and board members to certify about compliance. How would you like to have that discussion with your board? You know what, you're going to be on the line now. I need you to certify that we're, doing things right in the office. Not a very fun conversation to have with your audit committee. Pacira. Going to go kind of quick through this one as well. Smaller fine, 3.5 million. You may famously remember Pacira fighting the FDA on Exparel and things it could say about the drug. Well, now the government, I guess, came back, and years later, different division, that was a fight with primarily with FDA. But in this case, they're saying Pacira paid bogus research grants to physicians to get them to prescribe the drug. Some of them, these things, again, what can you do with this case? For example, your grant SOP should embody these takeaways that I have on this slide here. Should you ever say, yeah, I'll give you this grant, but you have to put my drug on formulary? Obviously not. Should not do that. Should your marketing executives be the ones deciding who gets a grant, or who's or should there be a sales goal attached or considered with a grant? No, these things are all pretty obvious, and you may have policies and procedures in place that say these things, but have you audited against them? Because the government will not give you credit for just having a policy. You need to enforce it, and monitoring is very important. Parting thoughts on the cases. Again, we could spend a whole day talking about all those cases, but there are more cases. I already mentioned this. The government's been very industrious. Maybe COVID will slow things down a bit, but I doubt it. What themes are you picking up on? These aren't off-label primarily. There's the one case that talked about inconsistent promotion. Promotion was inconsistent with the labeling, but they're generally all fraud and abuse cases. We have a new sunshine case in the mix here. Are we going to have more of those to come? The whistleblower aspect, that's big. Think about what types of skeletons are in the closet, and what if you're aware of something that occurred that was inappropriate, investigate it, and is there anything you can do to curb perhaps skeletons that are in the closet from coming back to haunt you? I'd say, learn from these cases, share them with your peers. I've worked in industry. I've worked with, last I checked, it was something like over 500 companies in my legal career. I understand the pressures are immense, but these are the types of stories that you can share with your peers that will motivate them to follow the rules. There is a lot of gray area in this industry. But the consequences of not being right can be career ending, company ending. Look at Mallinckrodt. I don't know what's going to happen to them. So think about those things. And again, if you need the court filings, I can send them to you. But these things should be integrated into your policies and procedures, but also audited against. We'll go through the Sunshine app updates kind of quickly here. There was the Support Act altered the Sunshine Act. And there's a final rule that was promulgated as well. I have the final rule on the bottom of the slide here for you if you want to read it. It's extremely long because it was not all about the Sunshine Act. There's only a small portion, or open payments synonymous with Sunshine Act. So I've, for you, carved out the most important aspects. The expansion of the definition of a covered recipient occurred. So starting January 1, you're going to have to track payments to PAs, nurse pracs, CNSs, CRNAs, etc. Well, certified nurse mid-housewife is the only other one. The one that's kind of interesting here that I call out is a clinical nurse specialist. So I have a sister who's a registered nurse, for example. She has a master's degree in horticulture, but not in a defined clinical area of nursing from an accredited educational institution. If she did, then I suppose she'd be caught in this. So something to think about the RNs that may be participating in meals. Best practice is to, collect information on all of the people that you make a payment to. Nature of payment categories expanded. We added debt forgiveness and long-term medical supplier loan of a device 91 days or greater. Acquisitions, this is a formatting issue. This should be pushed over a little bit to the left, but there's also bio payments to physicians. There's a category for that. This is kind of technical, so I'll skip over this briefly, but just in the past we had accredited and certified programs, or unaccredited and non-certified. They're now lumped into one category. This is for the real wonks out there like myself that have to do some of this reporting from time to time, but they manipulated or made some changes around, like added reporting requirements for the device identifier component of the unique device identifier for devices for medical supplies. They also brought back that you have to report NDC codes for drugs again. These rules go into effect on the 1st, and then just as a reminder, these are the new thresholds for next year. Those are adjusted according to CPI each year. All right, well, we've got about 10 minutes left, so this is the bonus surprise on the OIG special fraud alert on speaker programs. Here's the link if you want to read it. It's quite short, but 5 of these alerts were issued in the last 2 decades, so it's kind of a big deal. The quote here, this is right from the alert. This special fraud alert highlights the fraud and abuse risks associated with the offer, payment, solicitation, or receipt of remuneration relating to speaker programs by pharmaceutical and medical device companies. So what's the motivation behind the alert? This is Mr. Dembski's, the Office Inspector General Chief Counsel. He told Law 360, which is an excellent news source, by the way, in case you want more cutting edge news. You do have to pay for it. It's very good. Okay, I'll just read it here. He told Law 360 in an interview that drug makers should think very carefully about the risks of speaker programs, and in particular in-person speaker programs, given that the pandemic has demonstrated that high quality events can be held virtually. So the government, they saw an opportunity here and they took it. The reality is I work with a lot of marketers week in, week out. Some of them seem to love these remote meetings because there's less that they have to, deal with. So they do seem to, the remote type of format for a speaker program does seem to be very popular right now. What else do we have here? In summary, the OIG states that the pandemic is curtailing many in-person activities, that companies have decreased in-person speaker program related remuneration. So perhaps speakers are being paid less, and then the meals are not being provided as often. And that the risks associated with speaker programs will become more pronounced. I thought this was interesting. If companies resume in-person speaker programs, so they're basically saying risks are going to go up if you go back to the old ways. It goes on to say, the alert goes on to say, or increase speaker program related remunerations to HCPs. It's pretty interesting. Some other noteworthy points that I wanted to make. I was a little surprised it was this much. In 3 years, $2 billion have been spent on these services for speakers. It's a lot of money. This was probably, for me, the most hard-hitting, sentence in the entire alert. OIG is skeptical about the educational value of such speaker programs. All right, this flies in the face of pharma and AdvaMed. So I'm going to talk to one trade group tomorrow, and excited to do that. Well, I suspect the trade groups are going to come back with their own press release in response to this one. A couple other comments: such cases, some of the ones we discussed earlier, strongly suggest that one purpose of the remuneration to the HCP speaker and attendees is to induce or reward referrals. OIG, and then this is good. OIG recognizes that the lawfulness of any remunerative arrangement, including speaker program arrangements under the anti-kickback statute, depends on the facts and circumstances of an intent of the parties. They then come out with a suspect characteristics list test, is what I'm calling it. They use the word suspect characteristics, and I found this very fascinating. And I'll kind of summarize this. One element, the first element, little or no substantive information presented. The number 2 one, alcohol available. That's pretty interesting. Or a meal exceeding modest value is provided to the attendees of the program. It's pretty common to have alcohol available at these programs. So that would be a big change for the industry that, we'll see where this goes. We know the government does not like it now. So how are our companies going to react? The program is held at locations not conducive. We know that's been an issue for a long time. And most companies appreciate that. Company sponsors a large number of programs on the same or substantially the same topic, especially in situations involving no recent substantive change in relevant information. We're going to see in the Novartis settlement in a minute, these things come out as rules that Novartis has to follow now, and there's as part of their CIA. There's been a significant period of time with no new medical or scientific information. So they're basically saying you just are trying to have a social event. HCP, and I'll just say to defend this industry, they're assuming that the physicians that attend these knew about what was new when, a drug that was approved or something. Obviously, it's not always the case. HCPs attend programs on the same topic over and over. I'll call them frequent flyers. There's people there that don't have a legitimate reason for being there. They just want a free meal. Maybe it's a spouse, for example. The sales and marketing business units basically run these and decide who's going to speak. They perform ROI analysis. These are not my words. This is right from the government. And then the last one here is the company pays HCPs more than fair market value. So we're just about wrapping up here. I'm going to give you some closing thoughts, but does this mean that the OIG is banning speaker programs? No. This is from the OIG again. It's not intended to discourage meaningful HCP training and education. Rather, the purpose is to highlight certain inherent risks that providing remuneration creates. And drug and device companies and HCPs should consider the risks. So they do talk a bit in the alert. They go in, and they're trying to let the doctors know that if they're on the receiving end of this, that they are also vulnerable and culpable under the anti-fraud rules. So my recommendations and commentary, I'll give another quick quote for that on the OIG. Companies should assess the need for in-person programs given the risks associated with offering or paying related remuneration, and consider alternative, less risky means for conveying information to HCPs. In other words, the government is saying do not have in-person programs, have virtual programs. So what comes next, we'll see. Again, I think trade groups probably come back with some feedback. I ask you personally, do you think this helps combat bribery? Do you think it chills free speech? Does it do both? Will it change anything? Time will tell. And then I'm just wrapping up here. Is this all a harbinger of future OIG actions, or at least a tell of what OIG thinking is? It's certainly a tell. We all know that. But here's some information from the Novartis CIA. All programs are conducted virtually, no more in person. That's pretty big. No restaurant venues. Alcohol may not be served or available for purchase at such events. The budget is limited to $100,000 per product or indication. No more than $10,000 per speaker per drug or indication. Speaker programs limited to window of 18 months of approval. All right, so those are some pretty big aspects, and I think this is my last slide here. Things now, this is where I'm trying to help you all. So what, right? Scary government, you know, you got sales and marketing people doing all these programs. How do you react? This is what I would do if I were you. You know, get a policy and procedure in place for your speaker programs and follow it and audit to it. So once a year, you should do an audit to it. And that knows that makes the people know that are arranging these programs that they're going to be reviewed, and that if they're not following the rules, they're going to be held to account. Think about these suspect characteristics. Are you going to have alcohol anymore at your events? The government doesn't want alcohol served at them. I think that's clear now. Set guidance on when you're going to have someone that works. What if you have a medical director? Why not have them speak at the event? Why do you need to pay someone? Think about that. You know, you can read some of these other things on your own. Are your meal limits appropriate? Are you going to stop people from attending so often? Have you looked? Do you know if people are attending over and over? Who selects the speakers? How much are you paying them? Are your biggest, you know, if you take the 80-20 rule, are the big customers, that the 20% that makes up 80% of your sales, are they all on your speaker bureau? That, you know, if you look at the Lifespine case, the government really drilled into some of those aspects. Are you listening to compliance concerns, following up on them? Some things for y'all to think about. Last point, this is a little bit, I hate to try and scare you a little, but recall that nearly everything you do is subject to discovery unless it's successfully protected by privilege, which often gets shot up. I bring that up because in the Novartis case, for example, they had done their own internal reviews and found that there were some anomalies and issues with their program, but the government didn't come back and say, hey, good job. I see that your compliance function addressed this, but that doesn't matter. These rules are punitive. We all know that. That's how things are set up. So be careful out there. But thank you all. That's all I have. I'll hand it back over.
Thank you. We actually have a few more questions, and I think we still have some time to answer a few. So one question, or rather statement, virtual detailing means that there are now tangible, complete records of most, if not all, 2020 detailing events. Do you anticipate a significant rise in enforcement actions as a result?
I do not. No, I don't think so. But we'll see. Yeah, there is more documentation of everything, but I don't suspect we will, but maybe, you never know.
Thank you. Next question. Now that we have a settlement under the Sunshine Act, what are your thoughts on enforcement and investigations going forward? Will this cause a trend upward now that we have our first settlement?
I think it's a great question. And, if you go on the DOJ's website and read these press releases, for example, this was the first one I saw where the CMS responsible, party for overseeing the Sunshine Act did make a comment about that. So we'll see. Not to downplay the importance of that law, but the fines are limited to, the most you can be fined is 1.15 million. Compared to 9-figure settlements, it lacks the teeth that some of these other laws have. You can be excluded under the Anti-Kickback Statute and False Claims Act. But I do think it's very important for companies to follow the Sunshine Act. But we will see if more come out. I think it's an easy claim to add if you're a prosecutor and you've got kickbacks and they were never reported. Why not? I would, if I were them, I'd add it in.
Thank you.
So probably.
Thanks. And now for the last question, do all of the new covered recipient types have NPI numbers in the NPPE's database?
Yes, they're supposed to. So that that was one of the updates as well, that I kind of moved over quickly, but they are supposed to all be in the NPPES. So we'll see how that goes. You know, for those of you that have been doing this a long time, like I have, you remember back to August 2013 when the law went into effect, you know, and we had our first reporting cycle thereafter, and the year following, it was it was a mess. And so we'll see. There, you know, I think that the Open Payments group has really improved a lot. They've improved significantly about 3-4 years ago. But yeah, so we'll see if all that data makes it into the system. If it doesn't, you know, if you can't find someone, I think that's an opportunity for you to go back to the PA or whomever and ask them. You should also try and collect that information on the sign-in sheet at the time the meal is provided. But I know that doesn't always happen.
Great, thank you. So I think that's it for today. And if any other questions occur after the webinar, of course, feel free to contact Mark or Cord afterwards.